Andrea Kane, and I'm here with you again for HIT 421, Legal Aspects, Release of Information. We are still on week 7 because week 7 is both chapters 10 and 11. This is the second lecture video for this week. It's on chapter 11. We're still on the HIPAA privacy rule. We are still covering unit objectives 9.6.1 through 9.6.17, and that is in your syllabus. So let's move on and see what else we have to learn about HIPAA. If you want to follow along in your textbook, I am on page 243. 243. So the HIPAA privacy rule provides individuals with their rights to provide some control over their health information. Remember, the medical record itself belongs to the business. So the medical record belongs to the business, but the information within the record belongs to the patient. There were some states that did not allow individuals to get a complete copy of their medical record. And even today, you can't necessarily get a complete copy of your medical record, especially if there's psychotherapy notes, involved. And it's the opinion of the psychotherapist that it's not to the patient's benefit to have access to those notes. So there are still some things today that patients can't get access to. However, HIPAA came across and said to every state, there are certain things that you have to provide patients with in terms of the information in their record. First of all, they have to be able to have access. They have to be able to request an amendment. They have to be able to request an accounting of disclosure. So if you've disclosed the information outside of treatment, payment, or healthcare operations, you have to track that and be able to provide that to the patient. You have to give patients the right to request confidential communications. They may not get a copy, but they can request it. Patients can also request restrictions that maybe a family member is prevented from accessing their information, or they don't want it released to an old insurance company or that type of thing. Patients also can complain of privacy rule violations. They can contact the Office of Civil Rights and lodge a complaint that their privacy that the privacy rule was violated. And going back to request amendment, they can request that their record be amended. They cannot require that it be amended, but they can request it. So it gave patients in every state all of these basic rights and kind of leveled the playing field so that all patients would have some rights when it came to their health information. So access. Patients can access their own PHI that is contained in a designated record set, DRS. And that's why it's so important for each organization to establish what their designated record set is because that's what you have to be able to provide to the patient for their access. Again, there are exceptions to this. We talked about psychotherapy notes. Another example would be if there's information that was compiled for civil or criminal actions, that would be an exemption that a patient could not access, that you would never disclose. If their access is denied, there has to be an appeal process that their request, and if it's denied, that they can request that it be re-reviewed. Or that it may be appealed. There has to be that process there. It may not be subject to appeal, but it has to be somehow considered. There has to be a process in place that's the same for every patient if there's some type of denial of access. And you just want to be super, super careful of this. And if you're involved in this, you definitely want to have your legal counsel or risk management involved in how all this works. In terms of access, you may, as the organization, require that the request be in writing so that you're verifying the identity of the person who's requesting access. The covered entity has to respond within 30 days of the request being received. And so you have to make sure that you provide that within 30 days of receipt. If you can't, for whatever reason, then you are permitted one 30-day extension, but you have to notify the patient within that 30 days that you will be needing the extension and why you need the extension and when you think the information will be ready. So make sure that you're aware of all those little pieces and parts. You can impose a reasonable fee. And I am from my years of experience, I am strongly, strongly, strongly opposed to any fees for patients for access or a copy of their record. I just think it's a very, very bad practice, a very poor way for an HIM department to produce revenue. I think you end up having situations of bad feelings with patients and their families when you charge for copies of their information. So unless you have any other way around it, I would not do it. But that's not to say it can't be done. It goes back to that whole argument we had at the beginning, right versus wrong, ethical versus moral, legal versus ethical, all of that. State laws typically do permit charging, but I would definitely be very, very careful if you wander into that realm of making ROI a revenue producing item. So individuals have the right to request an amendment to their record. They can request the amendment. It needs to be in writing. Once you receive that, you have to process it very quickly. Typically what you do is you identify what they're asking to be amended. You identify the individual who made the entry that they're disputing, and you contact them to see if they are willing to amend that documentation. Sometimes they are, and they are willing to do that, and they'll amend the record, and then you can notify the patient that that has occurred. Sometimes they're not willing to amend it, and in that case, you need to keep either way, keep the request for amendment and the action, the agreement or disagreement by the individual who is requested to make the amendment. You got to keep all that information. And then you need to notify the patient again what the outcome was. Was there an amendment made? Was there not an amendment made? And then there has to be a process that if the patient wants to appeal that or disagrees with that, how do you handle that? Sort of like right of access. Accounting of disclosures. This was a huge one when HIPAA first came out. How in the world are we all going to keep track of all the disclosures that occur with the PHI? The rule says that if it's not treatment, payment, or healthcare operations, that's what you have to track. Some organizations chose to track all disclosures. And with EHRs now, that's fairly easy to do, is to track all disclosures, but some organizations still choose to only do anything that's not treatment, payment, healthcare operations. And that's probably wise because that's closest to the law. You have to keep track of the date of disclosure, who you disclosed it to, what was the purpose of the disclosure, and what was disclosed. So you have to keep that, be able to provide that, and you have to be able to do it at any given time for at least the past 3 years. But thankfully, like I said, with EHR systems, most all of this is done through release of information software that's integrated in your EHR. And so as you complete the release of information request in the EHR, this information is gathered, and it's just a matter of going in and running reports when you need to disclose it to the patient. Again, there are exceptions. So treatment, payment, healthcare operations. Again, if someone requested their own information, you don't necessarily have to track that. And then there's some other ones here that are listed. personally, from having lived this life, I would recommend that you account for as much as you possibly can, because you never know when or how you're going to need it. I mean, hopefully you never ever get a request from the Office of Civil Rights to defend something that you did or didn't do. But on the off chance that you do, the more information you have in your system that documents what you did or didn't do and why, the better protected you are. And also, the more you're able to relate to your patients who have requests or concerns or disagree with your decisions, you've got the information to be able to have a good conversation about, okay, here's why we didn't do this, or here's why we did do this, here's what the law permits, and just be very reasonable about it and gracious. Let's see, that's not really helpful to what we're doing, so I'm going to pass on that. Confidential communications. Yes, individuals have the right to request alternate routing or destination of PHI. And so, for instance, let's say that someone comes in and they have something taken care of in the ED and they do not wish their insurance company to be billed for it. They have the right to request that none of that information be released to that insurance company or routed to that insurance company, that anything related to that episode of care be routed to maybe their attorney or maybe themselves as an individual. And you can honor that. But if you don't know that and they don't tell you that, then you can refuse to do that. Patients can request restrictions on the uses and disclosure of their information. We don't have to agree as an organization on the requested restriction, but we do need to hang on to it and acknowledge that we have received it. Sometimes patients don't have it. Let me give you an example. Sometimes a patient will have a relative that works at the hospital, and they don't want their relative to have access to their information. If the relative doesn't have a job-related need to know, then yes, absolutely, it's probably blocked because it's not related to that. But if their relative is in a role, say quality management, or something where they're needing to go back and audit information and that sort of thing, the organization doesn't have to necessarily agree to the request of restriction. A lot of times it's a good idea to, and one thing I have always told employees and peers is that if you know the individual, don't work on their information. Give it to somebody else. You will, that way you're not tempted to look at things you shouldn't look at, or you aren't tempted to say something about something because you suddenly know it and you wouldn't have known it any other way. And also, so you're protecting yourself so that if someone ever makes the accusation in the future, you can show through audit trails that you didn't touch it, that you didn't do it. So, for instance, in a coding queue, if they had a family member or a neighbor's record or a friend's record come up into their queue, they could request that it be removed from their coding queue and given to a different coder because they were familiar with that person and they didn't want any chance of any issues coming up. And we also allowed employees to request that their information go differently. So let's say that there was a coder and she was going to have a surgical procedure and she didn't want her other coders to see it. We would go into the queue and we would move it into the coding manager's queue or my queue as director, and we would be the ones who coded that information off rather than her colleagues. But she had to request that first, and then we would honor it. So that would be an example of request restrictions and how we honored that through HIM. Individuals have the right to complain of violations. If they believe that their privacy has been violated or that we're not following privacy law, they have the right to complain to HHS. Those complaints are investigated by the Office of Civil Rights. But it gives individuals a place to go that if they feel that something wasn't handled properly or their rights were infringed upon, it gives them a place to go and lodge a complaint where it's investigated and determined one way or the other. What is a HIPAA breach? A breach is an unauthorized acquisition, access, use, or disclosure of PHI which compromises the security or privacy of such information. You need to know this definition, inside, outside, upside down, because you need to be able to articulate it, you need to be able to understand it. So make sure you understand this definition. It will be critical for you, not just for your test over these chapters, but also just in general in your HIM professional life. There are some exceptions to what is a breach and whether or not it's going to be something that involves liability. Many of the requirements apply only to unsecured PHI, and an impermissible use or disclosure of PHI is presumed to be a breach unless the covered entity or business associate demonstrates that a low probability the PHI has been. So there are some twists to it there, and you can read more about that in your book. You have to do breach notification as part of your mitigation activity, meaning you have to notify the individuals affected, and you have to notify HHS via their online portal. And there are specifics as to when you do this and how you do this. Your book will cover that, so I again refer you to your book. And I think at some point, is it this week that we go out and we take a look at that? Or is it next week? But at some point, we'll go out and take a look at some of the breaches that have happened and how patients' information has been. We usually do that a couple times during the program. HIPAA-covered entities and business associates are subject to HHS regulations. Anybody who falls outside of the HIPAA-covered entities and non-VAs is subject to Federal Trade Commission regulations. So if there's EHR vendors, third-party service providers of personal health records or EHR vendors, things like that, those are responsible to be investigated by FTC, Federal Trade Commission. Excuse me, but if they're a covered entity or a business associate who are listed under HIPAA or covered under HIPAA or addressed under HIPAA, that's HHS, and they have the Office of Civil Rights. Take care of that. So it goes through here, breach notification. And again, this is all in your book. In fact, let's see what page it is on. Page 250 covers this information. And then if a breach affects 500 or more individuals, you have to do immediate notification. And it also has to go to the local media outlets as well as the Secretary of HHS. And it gets posted on the breach portal. Research. HIPAA does affect research, and this is on page 251. There are requirements for authorizations and how the authorization can occur, and you can read through all of that. Then there's something called preemption. And this is on page 254. This is where I talked about how do you determine whether it's the federal law or the state law that you follow when it comes to protected health information and all that goes along with it. Well, first and foremost, you look at which one is most strict or more stringent, and that is the one that you have to follow. So if HIPAA is more strict or more stringent than your state law, you follow HIPAA because that's the minimum. If your state law is more strict or more stringent than HIPAA, then you have to follow your state. And that's what it means about preemption. There are some administrative requirements under HIPAA talking about policies and procedures, the fact that you have to designate a privacy officer, there has to be ongoing workforce training, you have to have mitigation processes in place, data safeguards, and document and record retention. Typically, the HIPAA standard is 6 years. There are lots of penalties and enforcement activities. And again, remember we talked about how there can be both a criminal aspect as well as a civil aspect. And there are some categories. There's unknowing, there's due to reasonable cause and not willful neglect, there's due to willful neglect that was corrected within 30 days of discovery, and then there's due to willful neglect that was not corrected as required. So you have several there. HHS contracts with a private entity to conduct random audits because they're no longer complaint-driven only. They actually use information and take a look at things. You have state attorney generals that may bring civil actions in federal court to represent citizens that are affected by HIPAA violations. Individuals who breach HIPAA can now be individually prosecuted. Yes, if someone deliberately violates HIPAA, they can be individually prosecuted. Not just their organization held responsible, but they as the individual who did it. And then there have been some recommendations for compensating individuals who were harmed by HIPAA breaches and violations. And this is it for chapter 11. So you have plenty to work on this week with chapters 10 and 11. And in week 8, we will move on to chapters 12 and 13. And that's the other half of HIPAA. We've been talking about privacy this week. But next week, week 8, we will move into the security piece. And that's the other half of HIPAA. All right, take care. Have a great rest of your week.